Let's talk about child custody. In Texas, the legal word for custody is conservatorship. When a judge orders conservatorship, the judge makes a court order. That court order lists the rights and duties of the people caring for the child. Once an order is signed by a judge, it is binding and enforceable. That means that you are supposed to follow it, and the other party can take you back to court if you do not.
Most of the time, the conservators are the parents of the child, but a non-parent, like a grandparent, other relative, or even a family friend, can also have conservatorship of a child, if a judge orders it.
A court case is called a lawsuit or a suit. Conservatorship orders are made during a suit affecting parent-child relationship, or SAPCR for short. An original SAPCR means the first suit that sets up the very first custody order for a child. A modification suit is the name of the legal process to change an existing SAPCR order.
So who can file a suit for conservatorship of a child?
Not just anyone can file a SAPCR for a child. You have to have a legal right to be part of the suit. That right is called standing. Parents almost always have standing, although a father may first need to establish paternity. This means that the biological father becomes a legal father with all of the rights and duties of a parent.
So how do you know if there is a court order for conservatorship of your child?
If you have ever been served with court paperwork about your child, even if you didn't go to court, there could be a court order. If a parent was served, meaning they were giving official notice that a court case was filed about their child, but then they never showed up to court or they never filed anything in response, the judge could still have signed an order. This would be called a default order.
Many people in Texas have gone through the child support process with the Attorney General. Some may not remember talking to a judge, but that doesn't mean there's no court order. If a parent is on child support, there's probably a custody and visitation order for that child.
So how can you get a copy of your order?
The district clerk of each Texas county keeps copies of all SAPCR orders made in that county. You can first start by checking with that office and asking for a copy of the order. If you are not sure which county made the order, you can submit a form to Health and Human Services called an Application for Court of Continuing Jurisdiction for a Child Inquiry.
If you went through the child support process with the Attorney General, their office may be able to provide you with a copy too.
Knowing what is in your court order is very important. Read it carefully to find out the following: what decisions a parent gets to make regarding their child, when a parent can spend time with the child, and how much child support was ordered and who is supposed to pay it.
If another party, meaning any other adult who is part of the order, is not following the order, it may be possible to file an enforcement case against them.
People who break the rules in the court order could get in trouble with a judge and might be held in contempt if an enforcement is filed. Contempt means you could be punished with things like fines, fees, or even jail time.
TexasLawHelp.org has links to information and self-help legal guides for getting copies of a court order, paternity, original SAPCRs for a parent or a non-parent, modifications, enforcements. Have more questions? Chat with us at the link below.